We will go ahead and call to order this meeting of the Temple Terrace Board of Adjustments on Thursday, January 25th, 2024. Our first item is the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, our next order of business is the approval of the minutes from the last meeting, which was a long time ago, back in June. I did find one error that we have already put in where it says the public hearing was opened by Chair Cope, and I believe you were running the meeting that evening. I was not here, so we will get that corrected.
Correct, and I found one more where I did not previously accent, so I will correct that as well.
Okay. Are there any other corrections anybody has found, or do you need a moment to look through? All right. You good?
Motion to approve it.
Okay, motion to approve with the two adjustments that we have already noted.
Yeah.
Is there a second?
Second.
Second. All in favor say aye.
Aye.
Any opposed? All right, the minutes are approved. The next item on there is the elections for the nominations of chair and for the nominations of vice chair, which it's hard to believe it's already been a year and a half. That flew by very quickly. So I'll say that before we get started, I've been very happy to do this. If you all want it, I'm happy to continue it, and I'm happy to get out of the way and let somebody else do it. Whichever way works. With that, I'll open the floor for any nominations.
I'm gonna nominate the current slate of officers for re-election.
I second that.
All right. Any opposed? I'm sorry. Let me try that again. Everyone for?
Aye.
Aye. Any nays? All right. Then the motion carries.
So, just for the record, if you can state who then is the chair and who's the vice chair.
In this case, I will be the chairman, and the vice chair will be Byron Longworth. And I'm Stan Cope, if you're not watching on TV. Since I'm sure both views will probably be people related to us, if not us. All right, the introduction of the planners. This is quite exciting because I understand from before the meeting we were chatting that for the very first time there is actually a full slate of people. There are no vacancies. We have everybody that is supposed to be in what position they're supposed to be in, so that's quite exciting. So I will turn it over to you for the introductions, if that's okay.
Okay, well, I'm not gonna, we have two new planners now. We have Miranda Anaya and we have Malik Hall. Miranda's a city planner, Malik is a planner, and I want them to tell you all about themselves a bit so they can introduce themselves.
Awesome.
Hello, good evening.
Good evening.
Miranda. I'm coming from Citrus County, which is about an hour north of here. I'm very happy to do city work now. Done many variances in my career, commercial, residential, some that have hardship, some not so much, some that are straightforward, some that are come like straight out of a movie. But yeah, so variances are always either very easy or controversial. So happy to be doing them again. But I started here 9 months ago, I believe, May of 2023. So it's actually a good thing that I haven't seen you guys because that means something's working. If you don't have a lot of variances, then people don't feel the need to deviate from the code. So that's a good thing. Thank you.
Oh, it makes me feel tall on the camera. So my name is Malik Hall. I started in June. I think actually maybe the day before y'all approved the minutes. It said June 22nd. Was that a Tuesday or?
That would have been a Thursday, yes.
I know whatever was the week after June 19th is when I started. So, but yeah, my background, I come from Pinellas County. Born and raised in Tampa, but I come from Pinellas County. I was an environmental specialist, so I did dock permitting, swim in the water for seagrass. If it's seagrass here, hey, shift your dock over here. It was cool. It will prepare me for my current job because I do a lot of the I review a lot of the site plans on the zoning side. So even though it's not as simple as seawall, body of water, and dock, I gotta, used to dimensions and proper labeling and setbacks and all that stuff. But other than that, I'm a USF grad. Got my bachelor's there, environmental science and policy, master's there, global sustainability at the Patel College. So that is, yeah, that's me. I'm happy to be here. Miranda's been a great supervisor. It was pretty just nice to have a job from county work. As she said, she was in county, or many things, but she mentioned the transition from county to city. Same thing for me. I wasn't used to the city. If I had a field trip or a field day and I forgot something, that's like another hour back north. Like, I'm done. It's over. But here, we haven't done any inspections yet, but once we start doing site inspections, if we do for zoning stuff, it's not like, oh my God, I forgot this. Oh, it's like 8 minutes at most. So, well, if traffic is decent enough. 15 at max. If there's something crazy going on, 15 at max. But yes, I'm happy to meet y'all. I'm happy to be here. And to echo what she said, hasn't really been many variances, so that's probably a good thing. Our code's not as difficult as people like to make it seem. So
I think it's because people just aren't getting permits.
no, you should have another discussion with our building official. They're definitely getting permits. Well, thank you.
Welcome, fantastic. It's nice to meet all of you. Welcome aboard. And I'm sure of that 15-minute drive, at least 7 of it spent down here at 56 and Fowler, right?
Coming from USF side, you never know. So.
Yeah, just roll the dice. Okay, I believe the next thing we have is some training points, and I see the city attorney is here, so I assume that is in your ballpark.
Well, I was told that we were going to be showing a PowerPoint, so I don't know if that's set up or not.
Brian's got it.
Okay, so this was, I believe, shown yesterday to our historic preservation folks, and it's just a general refresher since we haven't been here in a while with regard to quasi-judicial hearings and procedures. So I think we were going to do that first, and then when we're done with that, I was going to talk about hardships. So.
Hello, I'm Ernie Mueller from the Legal Department, and today we are going to briefly discuss the basics of quasi-judicial procedure. The oath you took for your office requires you to uphold the laws of the city, the state, and the United States. The board attorney will advise you on the laws as may be necessary from time to time. It is very important you listen to their advice. When you follow the advice of the board attorney, you not only protect the city, but yourself as well. As long as you follow advice, you are protected from lawsuits against you. If you fail to follow the attorney's advice, you might be held personally liable in a lawsuit related to that action. The city also may not provide you legal counsel in those situations. As a member of a public board, you are now subject to several laws, including Florida's Sunshine Law. All discussions on matters that may come before the board or commission between 2 or more members is subject to the Sunshine Law. That means that it must be noticed, open to the public, and minutes must be taken. Your regularly scheduled public hearings meet these requirements and are the correct time to discuss items. The following are not in compliance with the Sunshine Law. Discussions that occur in the back room during a recess, passing a note to a fellow member during the meeting, discussions at a neighborhood association meeting, or any other communications of board business not noticed as such, open to the public, and recorded in some manner is a possible violation of the Sunshine Law. This includes emails, text messages, Facebook posts, Instagram posts, tweets, telephone conversations, as well as the telephone game, where you tell someone to go tell another member. Also, all of these written forms, including your personal emails and text messages regarding board business, then become public records and must be retained according to the Public Records Law. It is better to just not create these records and potential violations. Communications on board business with fellow members is best handled at noticed public meetings in the sunshine. If you have a topic that you feel should be discussed, either send an email to the city staff, who can neutrally disseminate information that would not violate the Sunshine Law, or schedule it for discussion at a noticed meeting. However, matters pertaining to a particular application should only be discussed in the hearing on that application. Do not violate the Sunshine Law. If you do, you may be assessed up to a $500 fine. Knowingly violating the Sunshine Law is a second-degree misdemeanor and is punishable by a fine of up to $500 and/or imprisonment for up to 60 days. You will likely be suspended or removed from your office. Attorney's fees can be assessed and may be assessed against you personally unless you are following the advice of the board attorney. In addition, if there is action taken on the matter discussed outside the sunshine, that action could be voided. You must also comply with the laws on conflicts of interest. There are statutory conflicts of interest, and there are conflicts based on the appearance of impartiality. First, let's discuss statutory voting conflicts. You are required to vote unless a ground for conflict or recusal exists. Under Florida statutes, board members are conflicted and must recuse themselves if the matter will inure to their special private gain or loss. Special private gain or loss means an economic benefit or harm that would inure to the member, his or her relatives, business, business associates, or client. The economic benefit or harm should be fairly direct and immediate, not mere speculation. For example, your spouse is working on this project is a statutory conflict. That your spouse has a landscaping company and this project could hire them to provide landscaping if approved is not a statutory conflict. If you have a conflict, you must recuse yourself on the record, state the reason, and file the form with the city staff within 15 days. Even if there is not a statutory conflict, disclosure of a conflict and possible recusal may still be necessary. Consider whether it would appear to someone on the losing side that you may not have been completely impartial. Examples are, if you live or own property within the area that required notice of the property at issue, you should recuse yourself in this instance. What if you are within the neighborhood and either have been or currently are active in the local HOA that is opposing the proposal? Again, this should be disclosed and you may need to recuse yourself. What if your college roommate is the applicant? Once again, disclose, and you may need to recuse yourself. Even if there is not an ex parte communication, these types of perceived or real conflicts should be disclosed, and the board attorney will walk you through whether recusal is necessary. Whether your possible conflict is with the applicant or the opposition, it is better to disclose than to have a decision overturned because you failed to disclose. Florida statutes also prohibit soliciting anything of value in exchange for a vote, accepting anything of value given to influence a vote, attempting to use an official position for private gain, using non-public information for private gain, doing business with one owns agency, or having a conflicting employment or contractual relationship. These are all prohibitions found in the Florida Code of Ethics for public officers and employees. Unlike the previous slide where clarifying the impartiality or recusal from a vote cured the defect, violations of these provisions cannot be so easily cured. We are going to talk specifically about what is a conflicting employment or contractual relationship. A public officer is prohibited from having an employment relationship or contractual relationship with a business that is subject to the regulation of or doing business with their agency. Practically speaking, this could come up if you or a business partner represent someone appearing in front of your board. So if your employer or a client paying you come before the board, you would need to resign. However, And this is a big however. There is an exception to the statute for professionals that are on the board because of their profession. For example, if you are an architect on the board in the architect position, and your client that you provide architectural services to under a contract appears before the board, you can simply recuse yourself instead of resigning. If, however, you are on the board in a citizen position, you would be required to resign. If you are not sitting on the commission in the professional capacity, you will want to be very cognizant of whether someone that you have an employment or contractual relationship with might come before the board. A second part of this is worth noting also. Continuing or frequently recurring conflicts can also be a cause to resign. For example, you would not want your business partner to start routinely representing people in front of your board. Even if you fall within the exception mentioned above, a constant, frequent cause for recusals may still necessitate resignation. Okay, we've talked about the matters that affect the public hearing. Let's talk about the hearing itself. Staff will present the item. All staff departments with a presentation should present first. This is followed by the applicant, then comments from the general public. Then the applicant is afforded rebuttal. After rebuttal, the public hearing will be closed. The very next thing that should happen is a motion. All city hearings operate under Robert's Rules of Order. Generally, Robert's rules call for a motion, a second, discussion, and voting. Always in that order. Thus, discussion is appropriate on a motion, and a motion should be made immediately after closing the public hearing. New state law requires that every board decision to approve with conditions, or deny must include written findings. In order to allow the minute taker to accurately capture all the grounds for the board's decision and commit those to a writing, the motion must come before any discussion. Let's briefly discuss motions. The motion to approve with conditions, or deny should state all the grounds or findings that the motion maker believes supports the decision. The best way to support the board's decision is to have all the reasons for the motion stated in the best possible detail. The motion maker should cite the code section and all factual references that he or she feels support the decision. Board members may find it helpful to take notes for themselves during the hearing that they can reference them. Board members may find it helpful to take notes for themselves during the hearing that they can reference at the close of the hearing. However, board members should never pass these notes to other board members. Keep them only for reference, not communicating. If you are not the motion maker, you can still help. If a fellow board member makes a motion that you feel lacks code or evidentiary support, you can offer an amendment. For example, evidence of X and Y in the record also supports your motion. Will you accept that as an amendment? Is a welcome addition to all motions. If a motion is made but does not receive a second, it will die, and another motion is in order. Once a motion is properly made and seconded, discussion is appropriate. The chair may limit discussion if time is limited, but generally, board members have an opportunity to speak after the motion and the second, if they so desire. It is not necessary to speak, however. If a board member simply agrees with the motion, there is not a requirement that they discuss it. If, however, a board member disagrees with the motion that was made, this is the correct time to bring up concerns to fellow members. After a vote is taken, unless the vote failed, the matter is closed and should not be further discussed. If you have concerns after a vote has been taken, it is best to address these concerns to either staff or the legal department privately. The need to be impartial and act impartially continues even after the applicant has left the room, and you never know when a particular issue, applicant, or case may come back. If discussion is going long and not progressing, and if the chair has not called for an end to the discussion, any board member may signal to be called upon, and upon obtaining the floor, move to call the question. Call the question means to cease all discussion and take an immediate vote. If seconded and approved, no further discussion is allowed. However, generally, all members will simply agree to vote if another member calls the question. Under Robert's rules, almost all motions require the moving member to obtain the floor by signaling and being called upon to speak. Similarly, almost all motions require a second and a vote. Point of order does not require any of these. Point of order is used if you believe procedure has been violated in some way. If you believe an important part of procedure was missed, you can simply call out point of order and then state what you believe the concern to be. It is always best to obtain the floor first, but if you cannot get the chair's attention, always feel free to just speak up on important procedural issues. It protects the city to make sure proper procedure is always observed. Point of information does require you to obtain the floor first, but it does not require a second or a vote. Board members can use point of information to ask questions from staff or of the legal department. While questions may come up at any time, ideally, all questions of staff, legal, members of the public in support or opposition, as well as questions of the applicant, will take place before the applicant is given a chance at rebuttal. If additional questions come up after an applicant has already given their rebuttal, they may need to be afforded additional rebuttal time to address any evidence given in response to the question. Thank you.
Yes?
There was a phrase in one of the slides, any business entity subject to the regulation of the board. Isn't that basically every business in Temple Terrace?
Probably.
So you
Yes.
can't have so let's say like I'm hiring a termite person to come and do something at my house. They're subject to the regulation of the board if they are in Temple Terrace, so does that mean I can't have a contract with any business? Like my plumber or like there's gotta
If
be
you
some
have-
limitation here,
Well,
right?
no, I mean, if you have a business relationship that's more of a one-on-one, not that, you go to Publix and you buy your groceries there, and now Publix is building, they're adding on to their building. You're just one of a huge number. So that would probably not be a situation where you would recuse yourself. But if you've got a plumber and you've done business with him in the past and, you come to have, and you hire him every time you need somebody, you have an ongoing business relationship with that person, and you should probably recuse yourself.
Oh, wasn't that one of the, I thought that was, my memory might not serve me, but I thought that was a slide where it said you have to resign if, so I'm curious if having business relationships with anyone, I mean, it seemed incredibly broad, so that's why I'm struggling with it.
Yeah, I don't think you would resign for that one applicant. You
Okay.
just would not hear that one case.
Okay.
So,
I think sorry if I think I heard his question. Basically, it's if it's an ongoing thing, like for example, the relationship is with someone that has like an ongoing thing where they're petitioning for something every month. At that point, you would, like your business partner is the lawyer arguing for somebody else. That would be, but the single time plumber would just be that one vote.
Okay. Okay. Well,
okay. Anything else?
I had the one on the HOA, and I want to make sure I'm interpreting this. I would assume that if, for instance, the HOA I live in came before the board, that living in the HOA does not necessarily exclude me, but I would, if I was a board member or some other way participating, is your HOA, is that cause for recusal, or if you have nothing else to do but live there?
Yeah, a lot of times you have to look at each individual circumstance and see, how closely you are related to it. If the HOA is coming forward to request something that is specifically going to impact you and your property and your house, then I always say err or act with an abundance of caution. It's better to to recuse yourself. And I'm not encouraging recusals, because I have seen people who just don't want to make a decision. And so they just recuse themselves, and it's like, no, this is your job. You can't just recuse yourself because you don't want to make that particular difficult decision. But if it impacts you specifically, then you would probably be best to recuse yourself. If they're coming in for something that doesn't really impact you and it is on the other side of the development, then you could probably hear that case. But it's perfectly okay if something comes up and you see something on the agenda and it's causing you pause, contact me or contact the deputy city attorney and just ask, and we'll talk about what the situation is and come up with a conclusion for you. Okay?
Thank you.
Right? I mean, council members have done that before. They encounter things that they feel sometimes causes them a conflict, and usually they'll contact me ahead of the meeting and we'll decide what is best to do. So. Anything else? Is that it? But if you come up with some other questions, we can hear those, and talk about them after. I wanted to make sure that we talked about hardships. It's a difficult concept, and it really is the key to what you do. That because under the law, in order to get a variance, the person who's asking for the variance has to prove to you that they have a hardship. And there's different criteria in determining whether somebody has a hardship. What you'll often hear is people coming before you and they'll tell you a sad story, and oftentimes it's a personal story, and it has to do with somebody in their family is sick, or what they're being required to do is expensive. The cost is not a hardship, and people's personal health reasons are generally not ever a hardship. I've seen, not this board, not this city, I've seen people come in front of boards of adjustment and say, I want to build a carport, and it's going to encroach into the side yard setback, but I want to build this carport because I have a disabled person living at my house, and when they get out of the car, they need to be under a cover, and so therefore, that's my hardship. Technically, that is not a hardship because it has nothing to do with the land. And hardships are something that run with the land. The variance you give them is going to run with the land. And here, when this family member or these people no longer live there, that variance is still going to exist for there to be a carport on that house. And it will forever encroach into the side yard setback or the front or the rear yard setback. A hardship is something that you find that is unique to that piece of property. And if everybody else on the block or in the neighborhood has that same issue that they're presenting to you, that is not unique to that land. That is just something that everybody in that block has to deal with. The way that that is dealt with, though, is the correct remedy for that is not to get a variance for you all, but for them and their neighbors to come in front of city council and ask that that ordinance be changed. That's the way it's done, not to ask for a variance from you all. Because what happens is you grant the variance to the one, and now the next door neighbor who's got the same situation, now they want a variance. And now you're literally changing what the zoning and what the land use regulation, or not the zoning necessarily, but what the land use regulations are, or in that neighborhood, and that is not your job. So the other thing I wanted to talk about is self-created hardships. There may be a hardship, and it may be something now attached to the land, but if it is self-created, you don't get a variance. So if somebody has, say, built a parking lot, commercial property, they've built a parking lot, and now they want to squeeze in a a stage and a seating area, and now the parking lot's there, and the river is there, and they're trying to squeeze something in, that really is a variance that should not be granted. That is a self-created hardship. And anything, in my view, is anything that is new construction, rarely is there a need for a variance. Sometimes, though, the person is dealing with a piece of property that is unique. It is different than the people on either side of them. It's irregularly shaped. It's got some strange topographical thing going on top of it. And even if it's new construction, they may have a hardship because of the land, and you can grant the variance. But as we've had here, there was a lady who wanted to build a house, and one of the members here said, I could design you a house that would fit here on your very tiny little piece of land, because it was new construction and you just got to think outside the box. So, and she did come back and she had made some changes, and eventually the board did grant her a variance. So, and that's fine, but you know, when you've got new construction, there's almost always a way to make something fit. It might not be what the person exactly wants, but that's too bad. They bought this lot. This lot is never forced upon them. They bought this lot, and it's buyer beware, and you need to check and see. You come to the city and you check and see ahead of time. What's my building footprint here? What can I put here? What am I allowed to build here? You know, a person's not going to come and buy a residential lot and then say, oh, I want to build a 7-Eleven. No, you find out what's the zoning, what's the land development regulations pertaining to that piece of property. And if you don't do that, that's just too bad. As far as self-created hardships, one that is frequent, somebody builds a McMansion on their piece of property. They come back a year later, even 5 years later, and now they want to build an Olympic-sized swimming pool on the lot. Well, they filled up most of the lot with the McMansion. Just because they want an Olympic swimming pool, they're not entitled to an Olympic-sized swimming pool. And so the answer should be no to that variance request, because all a person is entitled to is to make reasonable use of their property. And if you've got a residential lot and you've got a house on it, you're already making reasonable use of your property. So it's too bad you either don't get a pool or you put in a tinier pool. So I've advised boards in St. Pete many years ago, where I finally said to them after probably 5 meetings, it's like, you guys have to stop doing this. Somebody comes in and wants a 20 by 50-foot pool, and you give them a variance to do that. And somebody comes in and asks for a 10 by 12-foot pool, and you give them a variance for that. Why didn't the people with the great big pool just put in a littler pool and not need any variance? So you don't get to just come in and say, this is what I want. Also, a rule, a law that applies with regard to variances, the variance that if you want to grant one, the variance that is granted must be the minimum variance that will make possible the reasonable use of the applicant's land or structure. So if someone says, I have a house and I want to put on a 15-foot porch extending out into the front yard, and it's going to encroach 10 feet into the front yard setback, is adding on a 15-foot porch necessary to give them reasonable use of their land? Now, if they've got a house, that's already making reasonable use of their land, and they probably shouldn't put a porch on at all, or fit it in and not encroach. But I understand people like porches. So, but rather than grant them variance for what they're requesting of that 15-foot one, you can say a 10-foot porch is going to fit perfectly fine on your house, and now you will only be encroaching 5 feet. That's the minimum variance needed. So you get to, you get to do a little modification up here. You're not stuck with what the request is. I have seen boards of adjustment, and I'm not encouraging you to do this by any means, but I have sat there and watched them totally redesign somebody's addition. Sometimes they've totally redesigned it in such a way that it's better than what the person came in with, and they didn't need a variance at all. And everybody went away happy, other than the person who paid the fee to come and ask for a variance they didn't really need if they'd spent a little more time or had a better architect or engineer, because some of the plans I've seen come in and they've been designed by experts, and I look at them and go, oh my God, why would they do that? Because it's a poor plan, and now the person is stuck looking for a variance when they could have fit it in better. So I wanted to say, and not so much for you all, but for maybe a previous board, variances are not to be given out as gifts. They should be granted sparingly, because the applicant who comes before you is either a property owner or developer who doesn't want to abide by the laws that have been established by our city council. These are our laws. Everybody in town has to abide by those same laws, and now the applicants who are before you, for whatever reason, they don't want to do it. So you have to be very judicious and very critical in making your decision to let somebody not abide by our laws. And again, what you have to look at is their piece of land. How is that unique? How is that posing them a problem? One very good example of when a variance should be granted is, we had a family come in. They had I believe they already had a house on their property, but they didn't have a garage. We all know garages are really important. They actually help the neighborhood, because now all the cars and the junk and everything aren't sitting out for everybody to see. They get to go in the garage, hopefully. And their property was, instead of a nice rectangle or square, was sort of shifted. So they had a slanted line really on one side of their property. And so when they put on a square garage, and garages are pretty much square or rectangular, you don't have a lot of options there because the car's got to fit into it. But they wanted to encroach just a little bit with one corner of the garage. It wasn't the whole side, it was just one little corner of the garage was going to be over because the lot line slanted. And that variance was granted, and I'm all for that. Those are the kind of things that should be granted because of an irregularly shaped lot. It was unique to the neighborhood. Everybody didn't have a slanted lot. And they were only seeking the minimum variance necessary to be able to put in a garage, to attach a garage to the house. Does anybody have any questions about hardships?
I do.
Okay.
Sorry.
Go ahead. No, go ahead.
Actually.
It's better now than when somebody's standing there and expecting something from you. So they're expecting that gift from you. So
One of the most interesting things that came up in the previous year was people who were trying to manifest a particular use on a particular zoning. So 2 examples. One was Florida College. The other one was the lady that you mentioned with the property near the river. And one of the arguments that we all seized on, and which seemed to enjoy the favor of the city attorney at the time, was that if the particular type of zoning is in a lot, for example, where you cannot build that type of zoning without a variance, then that would be a reason to grant that variance. So a reasonable use, for example, for a lot that's designated for a particular size of house, where you cannot actually build that size of house without a variance,
right.
would justify the variance in spite of the caveat emptor argument that you brought.
I mean, that's it. We basically had conflicting laws there. in that particular neighborhood, and you're not gonna find that in every neighborhood, but in that particular neighborhood, yes, there was a minimum house size. So, you know, it was almost, if they said, look, I wanna build a smaller than house, required, that would be a variance in itself. You know, I don't want to build, you know, if the minimum house size is 2,000 square feet and somebody comes along and says, I only want to build a 1,500 square foot house, that itself would be a variance. That was a very difficult situation. Those were oddly drawn lots. How and, you know, they came to be a long time ago, and that was a difficult case. I'm not saying that what you decided was wrong there. You know, you granted her a variance, and it was a difficult case. But again, I commend you for not just granting it right off. It's like, go back to the drawing board and come back with something better. But what made that also difficult for you is you had people who came from the neighborhood who said, I don't want that house there because my son and I play ball on that lot, or we won't be able to have our view through that lot anymore. You know, that's not a reasonable objection. You know, you don't get to use somebody else's lot, and you're not entitled to a view through somebody else's property. And I've run into that a number of times. I had a case years ago where a lady had bought a model condominium. It was set up in a parking lot as a model for condos that were being built. And when they were done with it, they sold her what was essentially a box. It didn't even have any, I don't even know if it had any windows in it. And she bought this box, and she owned a lot, and she wanted to now set this box on the lot. Well, the neighborhood was all upset. They didn't want the box. They said, and a few of them said, well, now we're not going to have the view of the lake because now this is going to be here. Well, you know, too bad for them. She could have built a 3-story house there, and they would have even lesser of a view. But, you know, in the end, I forgot what kind of variance she was looking for, but she ended up working with, not this city, she ended up working with the city at the time to kind of make this thing look more like a house, you know, and she was told you had to put windows in it, and she put a front porch on it, and she put a roof on it and things, and turned it into a house. And in the end, the neighbors were actually very happy with how it ended up looking, because it changed. But, I mean, we had all sorts of people in the audience going, no, no, no. And the board had to ignore them because their reasons for objecting just were not legitimate. So.
Glad you mentioned that, because the argument from the other side was it's an unbuildable lot. She purchased an unbuildable lot. And then that was in conflict with the fact that it was actually zoned to be built on.
Yes.
In a particular way, so.
Yes.
So
all you could do then is grant the minimum variance necessary for her to make reasonable use of the land. And sometimes it's a foot, sometimes, you know, maybe in her case, it's 20 or 30 feet. But nobody said this was an easy job for you. So
I'm not bothered.
But that's it. And one of the things is you have to be hard-hearted sometimes. I mean, when I would be picking a jury on an accident case and somebody was injured, one of the things I would ask them, are you able to be hard-hearted when you hear that somebody was injured? If you don't think that the city was at fault for the accident, even though the person is sitting here, you know, with a cast on their leg and the neck brace on, and you believe they were injured, if we didn't cause the injury, are you hard-hearted enough to just say no to them? I only had one person say they weren't. You know, that no, they're too soft-hearted, they're not going to be able to do that. Frankly, they probably just wanted to get out of jury duty, but, you know, you have to be that way, and you have to be able to face somebody sometimes and say no. So, you know, we had an instance here. I don't think I was even here that night, but, you know, somebody had built a gigantic pool house without a permit even during COVID. This thing encroached. Yes, it's all there. What's the remedy? You tear it down. But they were granted a variance. Me, I would have said no. And what made it even worse is they did it without a permit. They knew they were doing it without a permit. So it's hard. I saw the Board of Adjustment once in St. Pete make somebody tear down an entire garage. It's like they built this thing, it encroached into the front yard setback, it was big, and they finally they said, no, you tear it down. And that was probably the worst thing I had ever seen, but they did it because there really was no other answer. It should never have been, it wasn't permitted, it should never have been there in the first place. So, let's see. One thing I'd wanted to read to you, if I can find that. I think it had to do with self-created hardships, and it was a court case, but no, I'm not seeing it. Oh, yes. It had to do with, I think, a self-created hardship, and this was a quote from the judge there. He says, when the owner himself, by his own conduct, creates the exact hardship which he alleges to exist, he certainly should not be permitted to take advantage of it. So, and that's the McMansion case, and those are just common ones that, I've seen many, many times throughout the years. So that's, and the law itself, I've had people come in and try to say that basically that the law that itself is their hardship. Well, yes, we know it's your hardship. That's the thing that's, that you've got to abide by. But they cannot argue to you that the zoning law is their hardship. So, again, you always have to keep looking, is it something related to the land? So they've got to point to something on their property or about their property in order to get a variance. So, any questions?
Any other questions?
Anything about the PowerPoint that you saw? Ernie and I are always here, so if you think of something later, you're, pondering this evening.
Just painting you, huh?
So anyway, if you're having heartburn over it, just, feel free to give us a call. We're perfectly happy to talk about it and answer any questions or work through it. It's easy for me to say this. I advised a Board of Adjustment for 20 years in St. Pete, and now I'm here advising this Board of Adjustment. So I've seen many, many types of cases, and here you don't meet very often. In St. Pete, the Board of Adjustment met every single month without fail, and sometimes the meetings lasted the entire day. I mean, they'd break for lunch and come back. That's how many cases that they had, and that's how often, they had to listen to it. But, and they'd go through cycles with the change of members. I mean, for a while there, they never saw a shed that they would allow. They just hated sheds. So if that, shed was encroaching, no way, you move it into the buildable space, and I don't care how bad it, they didn't care how bad it looks. They were not going to give you an inch to put in a shed. So, but, and then I'd see them granting, a different board granting sheds all over the place. So, or granting pools. For a while, I had a board, I mentioned, they just somehow felt like every person in Florida was entitled to a swimming pool. And so they would grant any kind of a variance. And so I had to talk to them about that. And, we needed to pull back on the pools that were being granted. So, I've had a lot of experience with this, and I'm perfectly happy to talk about it to you, and you'll become an expert on variances too. So, all right.
Anything else?
That's it from me.
All right, thank you. Looks like the next item we have, I don't know what this is for sure, but I think I can guess from it, is about a request from the staff for quarterly work sessions.
So yes, good evening again. So last time we saw y'all, gosh, I think was in June maybe, and that's a long time to not meet, not talk about variances, not talk about what's going on in the city or any new legislation that came down relating to variances, zoning, things like that. So what we would like to do is, regardless of whether we have any variance requests, at least, let's get together maybe once a quarter and have a training session. If we're meeting every month with variances, we may not need to do that. But I don't want to go 6 months again or however many months without having to sit down, just for continuity. And so that's a request we have, and that probably would take some kind of motion from the board to make that happen.
All right. Do I have a motion to hold quarterly work sessions with the city staff?
Should we vote on that as a motion, or should we just have a motion to schedule a quarterly work session in 3 months? That would be one or the other, I guess, might work. I don't know.
We just schedule the next one. Make sure I understand. You're saying just schedule the next one, not say we're going to do it every quarter, but we'll do one next
Go ahead
quarter.
and do it, yeah.
Yeah, just go ahead and do it. I mean, even if we have a motion and we vote that we want to have them, we'll still have to schedule one anyway, so that'll be 2 motions, I think.
Oh, one second.
Sure.
Okay, so what we were thinking is to do a motion along the lines of you guys will motion to have quarterly meetings if needed. But what that would mean is if you have a meeting in between, like a regular meeting in between that quarter, you don't necessarily have to have that quarterly meeting. Does that make sense? I probably didn't say it quite clear.
Yeah, you got it.
but-
Actually, you did really well. I got it.
But we wanted to make sure that you're meeting at least once a quarter. So you don't necessarily have to meet at that quarterly meeting if you've already had, like, if we come to meet for a variance in between. We just don't want 6 months of
Yeah.
not
That
meeting
makes
and
sense.
not keeping it fresh in your head.
You want to redo your motion?
So I'll motion to institute a policy where if we have not met for 3 consecutive months, that a work session will be scheduled for the subsequent 4th month at any given time.
I second it.
All right. I have a motion. I have a second. All in favor, say aye. Aye. Any opposed, say nay.
Nay,
Nay. All
I
right.
just don't want.
Had to crunch those numbers.
It's okay.
Had to crunch those numbers in my head there.
So we have 4 ayes, we have 1 nay, so the motion carries.
Okay, all right, sure. I have a general question, if that's okay. Could I bring that in there?
Please, go ahead.
I know that there's a historic preservation board now. And this board also has the power to grant variances. I'm curious if they've had any variances so far. Does anyone know?
No.
They have had none. We've had 2 organizational type meetings, but they've received no variance requests yet.
Should they, I mean, since we're all dealing with variances, should we bundle the work session in some way? I don't, just,
Oh, you mean include them on our work?
yeah, you know, it might
Their
reduce,
variances are different.
yeah,
They're not the land, it's more the structure. Like they want to change their 1920 windows to, impact glass, super modern.
yeah,
Not gonna fly.
Yeah.
That type of variance.
right.
So they have a different scope of rules to follow.
Okay. All right.
Do you have any other questions? Or did anybody else have any general questions? Because otherwise, we're done.
All right.
If there's no further questions, do I have a motion to adjourn the board meeting?
I motion to adjourn.
All right, a second? All right, all in favor? Aye. The motion carries. We are adjourned. Thank you very much. Good to see everybody again.
Happy New Year.